It is a great honour and privilege to be here in Seoul and at the Korea University, and particularly with people who have an interest in shipbuilding contracts. As Professor Kim has said, I'm going to give a comparative study of the SAJ and new build forms of shipbuilding contract. I have a thesis or a message which I would like to start with, which is I believe that NEWBUILDCON represents a major advance in the contracting process of shipbuilding, and it should become an industry standard. That may be a slightly controversial statement to make, because since NEWBUILDCON was published in 2007, the shipbuilding industry has been quite slow to use it. Indeed, when it was being drafted, the shipbuilding industry worldwide did not wish to have any involvement in its drafting, or very little. Nevertheless, BIMCO drafted it to be an evenly balanced contract between builder and buyer. So I am looking at these two contracts from the point of view of a marine lawyer, in the same way that a doctor only sees ill patients. It can be said that a lawyer very often only sees contracts when they've gone wrong. Well, that's of course if you're dealing with the dispute resolution side. I'm also involved in drafting them, but when they go wrong, that's what you see, and you pick up trends. You pick up things and you are able to say to your clients, if only you had done this, things would be much better. So I approach it in that vein, and also from my maritime background, I have been a user of shipyards, albeit for a short period, and I am currently engaged in the resolution of shipbuilding disputes for Korean companies, so I'm very much aware of the commercial pressures at the moment. I must start by declaring an interest in NEWBUILDCON, in that I had some involvement in its drafting, in particular in relation to the refund guarantee wordings that are annexed to it. So that possibly explains where I'm coming from. So I'm hoping to communicate to you some of the distinctions that I've seen as a lawyer. Why compare these two forms, SAJ and NEWBUILDCON? Well, in many ways they represent to me the old and the new. The SAJ form in its current form, I think, was drafted in 1974. It has quite an old style, and as its name suggests, the Shipbuilders Association of Japan, it is quite a heavily biased contract in terms of looking at respective rights and obligations. Whereas NEWBUILDCON is designed to be more evenly balanced. However, they are both forms that are in current use, and I think it is important to look at them because I believe NEWBUILDCON provides a valid, not the only alternative, but a valid alternative to SAJ. And I think if we can all help buyers and builders make an informed choice when they come to contracting, that will be a small service to the industry. Why did BIMCO draft NEWBUILDCON? Well, partly, of course, because it likes to have a full suite of maritime contracts. But I think there are a number of reasons why it was a good idea to come up with an entirely fresh, entirely new form of contract. I think the first point is that SAJ does use some archaic language. Its very first word is witnesseth. Now, who ever uses that word today? Lawyers don't use it in England, so why should people who are using contracts written by lawyers? There is, amongst English contract lawyers, a strong feeling these days that a contract provides more than a list of rights and duties. It should be in the context of project management, and building a ship is one of the biggest projects that you can have. In one sense, it is the rules of the game. And unless the people who are playing the game understand those rules, so that the executive people in the shipyard or in the buyer side actually can understand it, can go through it, can quickly turn up and read it, then that contract is not really serving a function. If you need to go to a lawyer to understand what the wording says, fundamentally, I believe there has to be something wrong with it. Looking at the two contracts, and I've only got an SAJ here, which is in this book, but it doesn't actually take very many pages. It's quite thin, whereas NEWBUILDCON is quite a chunky type of document. Now, I fully accept that the SAJ has been amended, heavily amended, and used in different ways. And we will come on to that at the moment. But I do think that NEWBUILDCON, as a fresh document, carries a lot more detail. And I believe that a lot of that detail is necessary in order to provide this framework or the rules of the game of a $100 million construction project that's taking a couple of years. There are a couple of examples as to why it is necessary to have a more evenly balanced document between the parties. The SAJ, in Article 1.4, deals very briefly with subcontracting. And generally, the regime in the SAJ is that the shipyard can more or less subcontract at will. That is, I think, fundamentally wrong for a piece of equipment that is as complex as a modern ship, that's got to comply with so many regulatory rules and laws and be safe. If you are contracting with a particularly well-known yard, you will have your reasons for doing that. You may well be paying more to go to a yard with a good reputation than going to one with a poor reputation. Or dare I say it, of a yard with no reputation at all, which are some of the problems that we've been seeing in China with these greenfield sites. So it just seems entirely wrong that a builder should be able to subcontract to a greenfield site, to a yard without any reputation. Another example is the force majeure clause in Article 8 of the SAJ form. Of course there's a force majeure clause in the NEWBUILDCON as well, but I think it's rather more carefully drafted and provides the buyer with a little bit more certainty. Perhaps most fundamentally, the SAJ form does not talk about who designs the ship, which really is a glaring error or omission. I think it uses the words that the SAJ, that it will build, equip, launch and deliver the ship, but there's no mention of the word design. Now, clearly it's of vital importance that the buyer knows who has designed the ship. It's important to the builder as well, because you do get cases where a third party has designed the ship. Sometimes the buyer will have had the ship designed by a third party and wants another yard to construct the ship. That's fine, because you make it clear who is responsible for design. But it is fundamentally wrong, in my view, that the contract is silent as to design. In fact, in SAJ, it's even worse than that, because there is an article where it does talk, the word design is used once, but it's in terms of plans and drawings. And so there's a little implication there that there is a responsibility for design on the builder's part, but it doesn't make it clear. And as any lawyer will tell you, it is that type of issue where there isn't clarity that gives rise to disputes. Another significant difference between the two forms of contract deals with the repayment of instalments paid if certain situations happen, such as the builder becoming insolvent or whatever. Now, a lot of these points that I've just raised, your answer to me will be, well, the SAJ form is heavily amended. In fact, so heavily amended that there is a sort of printed annex to it with other terms that people use. But in reality, of course, what happens, or what has happened, is that a shipyard started to use the SAJ form, probably perfectly acceptably, 20 or 30 years ago, and it has added clauses, and then something happens and they add another clause, and then there's a dispute and they don't like that, so they change another clause, and then they add something else, and so it gets longer and longer. But it evolves rather than actually doing a formal contract drafting process of going through the whole document. And that is why you get some most extraordinary, which I can say because I've seen them, wordings, which have come out not because they have been drafted through great thought. It's probably impossible to say quite what the genesis of some of these clauses has been. And what NEWBUILDCON does is to start afresh with an up-to-date wording, which you can then change to suit your circumstances. So I would say SAJ, very much a creature of its time. If you look at all the references in it to having to get the approval of the Japanese government for foreign exchange payments, you know, that is now completely defunct. So there's no point in having that sort of clause in a contract. I mentioned that SAJ is actually quite short, and one of the reasons for that is that there aren't many what we would call boilerplate clauses. People familiar with the term boilerplate clauses? Yeah. Is that a common term in Korea, boilerplates?
Yes, 부동문자.
Right. I think yes, they're the clauses that you put in to protect each party's position and to make it clear what the position is, which probably just get put in everyone. I think the term comes from the American printing industry in the days of printing. And so what you've got in NEWBUILDCON are those clauses such as rights of assignment, rights of third parties, which all good contracts should have. So this might suggest that I think NEWBUILDCON is perfect, and of course it's not. No contract can ever be perfect. And one of the factors is that actually NEWBUILDCON has adopted a lot of the wording, or at least the principles, from SAJ. And I think part of the reason for that is where the contract is based on English law, you have got a large body of case law out of not just the English courts, but to some extent out of courts such as Singapore and Australia, which use the same common law system. And that case law helps us to interpret the words. So I think where wording in the SAJ form has been used and tested and found to be sufficient, a lot of that has been incorporated into NEWBUILDCON. It's worth looking at or comparing the form. The SAJ is printed with close printing. There are a few gaps where the parties can put in the details, but that's all. NEWBUILDCON is, I think you've got one in front, is done on the standard BIMCO format using a lot of boxes. And then once you get to the text, it would in theory be possible to sign a contract, as is often the case with charter parties using a similar form, without actually amending the text at all. So you put all the details in the boxes and away you go. And I think that that has strengths and weaknesses. Two of the strengths are, first of all, it is very easy to amend. And as a lawyer, when I'm asked to edit BIMCO documents, I can go onto the BIMCO website and edit them quite easily. And of course, once you have edited it, it becomes a PDF document, and you cannot take anything out without it being marked up, and anything added is marked up. So it is totally clear to anybody receiving that document how you have changed the original wording into what you are presenting. Now, just think of the money that saves parties in legal fees, because if you ask a lawyer to review a 50-page contract, he will start on page 1 and work his way through. With a BIMCO document, you can go through much more quickly because you know that anything that hasn't been amended is what you expect to be there. And so that is, from a practitioner's point of view, a lot easier. So it's easy to amend and it's marked up. But there is a problem. Well, there are two problems. The first is that sometimes people make unauthorised copies of these. And I once saw one, it wasn't a NEWBUILDCON, it was another BIMCO document. And it was very similar. They'd even gone to, they'd scanned in the BIMCO's logo. I think they'd even scanned in the copyright sign. Scanned it looked almost identical. They'd left one word out, which was the word not. And that was before the word liable. So it changed a complete clause as to one party from being not liable to being liable. So, and of course, unless you had spotted it, there's a danger that you could have thought that that document was a proper, genuine BIMCO document. And of course it wasn't. So there's a little warning there. Check it is the genuine thing. To be honest, it would take BIMCO NEWBUILDCON is such a long document that I think people probably wouldn't bother, but it is a thing to worry about. The other disadvantage of this form, and I do think this is a real disadvantage for shipyards, is that many shipyards want to have a standard form which they have reviewed, they have probably reviewed with their lawyers, with their commercial people, and it's sitting there, and when a potential buyer comes through, they can say, this is our standard form, and then they can use that as the starting point for the negotiation. The problem with this is a shipyard could do that with NEWBUILDCON, but it is immediately apparent to the person receiving it what changes the shipyard has made to the standard text. And so let us say the market is strong from a shipyard's point of view, and they are in a good, strong bargaining position. Then they may want to change some of the terms to make them more favourable to them because they have the commercial ability to do so. But it does rather stand out like a sore thumb to anybody and tends to invite the other party to negotiate further. So that's, in a sense, a psychological problem, but perhaps not a massive one. So the style, it basically, as I've said, is the language is in plain English, and so it should be much easier to understand. Before we look at the terms, the specific terms, or the comparison of the specific terms, I think there's one other important point, and that you tend to look at shipbuilding contracts as between two parties, the builder and the buyer. It's really important these days that the banks are involved as well, because without the banks there won't be finance, and without the finance there won't be a shipbuilding contract. And so I do believe that presenting a bank who you are seeking to get outline approval for a finance facility with a NEWBUILDCON is going to arguably assist in the overall project. The chances are that the person in the bank who is looking at it does not have a great degree of expertise in shipbuilding contracts, and certainly when it gets up to credit committee approval stage, almost certainly they won't. And presentationally, I believe that NEWBUILDCON as an industry standard document is going to carry more weight, a bank may feel less exposed. And of course that's before you start to look at the slightly more detailed and indeed slightly more evenly balanced terms relating to, for example, the buyer's ability to have the money refunded if the builder defaults for some reason or another. Let's look at some specific terms. The first one, which I've already alluded to, is design risk, which, as I say, SAJ does not cover. SAJ, I think it's Article 21, does, however, say that the contract price includes the cost of design and supply of drawings. Now, whether that is an implication that the builder is obliged to design the ship, I don't know. It's an open question, but at best it's rather unclear. In contrast, and I would say logically, NEWBUILDCON deals with design right at the start in clause 1 by saying it is mutually agreed between the builder and the buyer that the builder shall design, construct, test, survey, etc. Clearly, if the builder isn't doing that, it is very easy just to delete that, and that is what I'd expect to do if, for example, you were using a third-party designer. The next point, which again I think I've touched on, is subcontracting. And NEWBUILDCON mentions the maker's list and the specification. And it then imposes on the builder the obligation to obtain consent from the buyer if it wishes to subcontract outside what has been agreed either in the specification or in the maker's list. So, for example, I can think of, in England at the moment, they're building for the Navy 2 new aircraft carriers, and the hulls are being built in different shipyards, or sorry, sections of the hulls are being built in different shipyards. So quite clearly, that will be part of the deal. In terms of a commercial ship, a straightforward bulk carrier type of purchase, what is important is that, as I said earlier, the buyer either knows who is going to be manufacturing, or else the thing is so minor that it doesn't matter. The builders, and I think this is just an example how rights and obligations are balanced in NEWBUILDCON. The builder's right is balanced by the buyer cannot unreasonably reject such a request. So there's a mechanism. The builder makes a request to the buyer to outsource one of the parts, and the buyer should then respond to that, and shouldn't refuse unreasonably. Now, what does that mean in law? Well, if the buyer does refuse, and if the builder feels that he is refused unreasonably, then it would be for the builder to make a claim for breach of contract and say that that refusal was unreasonable. And it's a very subjective test. I think a court would look at it from the point of view of the buyer, and was it reasonable for that buyer, in the buyer's situation at the time, to make that refusal. And it's a difficult one. I mean, it's very difficult to actually have a test. But hopefully it balances things out. And in the context of the majority of shipbuilding contracts, it should always be remembered that there is a tremendous degree of cooperation, because if there wasn't, these ships wouldn't get built. And that degree of commercial cooperation will actually make sure that these points are carried through in most cases. The next point, which probably sounds like a very minor point, is simply that of currency. The SAJ's terms regarding currency, as I mentioned, requiring Japanese government approval and payment in yen, that obviously is completely out of date. But any well-drafted commercial contract should specify both the currency of the price, but should also specify that payment must be made in that currency. Because if you don't do that, in theory, there can be an argument as to exchange rate differentials if somebody is paying in a different currency. Sometimes it may actually be wished to pay in a different currency, but that's up to the parties. NEWBUILDCON in some places has actually shifted things towards the builder. And an example of that is the right to set off payments. And under the SAJ form, there is no express provision stopping the buyer from setting off claims that may have arisen during the process from the purchase price. And therefore, it is an arguable point, and parties don't like arguable points, they want clarity. So, for example, there is a very clear statement in NEWBUILDCON that liquidated damages can be deducted from the final instalment, the delivery instalment. That takes us on to the topic of liquidated damages. Obviously, there are provisions in the SAJ form regarding LDs, as they're known, and they're reasonably well drafted in that they do set out a certain tolerance. So, if the ship is just off spec, let's say in terms of engine fuel consumption, as long as it's within a certain margin, then the ship is still delivered. There's no right to reject, but there is compensation payable to the buyer by way of a deduction, of course. Now, what NEWBUILDCON does is to take these provisions for liquidated damages and just put them in a little bit more detail, so it's quite clear what they are. And interestingly, they've left a blank space to allow the parties to put in other areas of liquidated damages that might be applicable on perhaps a non-standard type of ship. It's actually quite interesting, and again, we're talking almost about the psychological impact of a contract. But the very process of going through and filling all these boxes in, where sometimes you have to perhaps make a choice as to the governing law, for example. It just provides that opportunity for both parties to think and to just to evaluate these points, which I think very often hasn't happened in the past. I can think not so long ago of a shipbuilding contract, which ended up in a sort of horrible dispute. And this had been presented by the shipyard on its standard form. The buyer, I don't think, had ever reviewed it. They had just accepted it as it came. And that's why I think going through the NEWBUILDCON and filling in the boxes actually prompts the parties to think, well, we could do that, or should we choose that? So LDs, there is room for creativity there. So it's not just reduction in speed, deadweight capacity, fuel consumption, which are the typical ones, and of course delay, but also you could put in whatever was appropriate in the circumstances. I mean, it could be the number of containers that the ship can carry. It could really be anything as long as you can evaluate it. Buyers' modifications, in fact modifications generally, it is really important in any big project contract, whether it's shipbuilding or construction of tower block or whatever. It's really important that the parties have a mechanism for changing the contract, for modifications. And in the context of shipbuilding, of course, we're looking at three groups. We're looking at modifications requested by the builder, mods requested by the buyer, and modifications which become necessary because class rules have changed or flag state regulations have changed. And so what NEWBUILDCON does is to provide a much clearer mechanism for how whichever party it is triggers a request and requires the other party to make a decision and then sets out the implications in terms of timescale and cost for going through that modification. Interestingly, thinking about class modifications, in this respect, NEWBUILDCON is more favourable to buyers. If you look at the SAJ scheme, the builder agrees to deliver a ship which is compliant with the class rules in force at the time the contract is signed. And the NEWBUILDCON goes further than that, which I think is logical in many ways, because if there's been an important class change, and we're talking about something here probably happening quite suddenly, quite quickly, and that probably is because there's a safety reason. The parties do, or the buyer needs to have that sorted out. Although there's then the counterbalance, which is the delay and cost to the builder is then passed on to the buyer. The provisions as to sea trials are very much more detailed in NEWBUILDCON, and they are objective tests, the sort of things that, and I'm sure more detail is probably put into the specification, which will be annexed to the contract itself. But the contrast with SAJ is, under SAJ, it is up to the builder to decide when the weather is fine enough to do the test and whether the conditions are right. Under NEWBUILDCON, it is objective and it sets out the requirements. I don't know the position under Korean law, but under English law, you have implied terms. So you can have a signed contract, and I'm sure you're all aware of this, you can have terms implied by custom and usage, by necessity, by statute, and by case law. Putting it very simply. So, for example, the Sale of Goods Act 1979, Section 14, requires that goods are of satisfactory quality. And arguably, this is a contract for the sale of goods. It applies to this, even though the Act was designed for the sale of washing machines. Under the Sale of Goods Act, you can exclude that if you're dealing with a business-to-business contract. So it is good drafting in most commercial contracts to exclude those statutory implied terms. That happens in NEWBUILDCON. It doesn't happen in SAJ because it was written before those particular statutory implied terms came into force. Another difference is assignment, the right of assignment. It is really important that the benefit of the shipbuilding contract can be assigned by both the builder to its bank and from the buyer to its bank, and that is allowed there without actually, I think you have to give notice, but you don't actually have to get the other party permission. It is assumed that in today's world you have to do that, whereas under the SAJ form that isn't there, and that I've seen lead to problems even on heavily amended SAJ forms where somebody wants to do some sort of security assignment to a bank, and actually you need the shipyard's permission, and it comes at a time when the shipyard's being particularly difficult, and it just makes the commercial position a lot more difficult. The law and jurisdiction clauses, they're broadly similar because very often the SAJ will just have cross out the sort of Japanese Tokyo arbitration, and will put in some form of London Maritime Arbitrators Association clause with English law to apply, or something similar, occasionally Singapore law or Singapore arbitration. And that is very similar in NEWBUILDCON. And it also preserves what generally happens in SAJ style forms, which is where you have disputes of a technical nature in terms of whether the ship complies with the specification being referred to the classification society, and claims more of a contractual nature being referred to arbitration. But there is the choice. We could go on and on and on, because you could almost cover the whole field of shipbuilding. But I think my 45 minutes is up, and I think that might be a good point at which to stop. I think it's very interesting trying to compare these topics, these two forms of contract, and as a closing note, I would say that if ever you are looking at a shipbuilding contract issue, a very good place to start is the list of clauses of the NEWBUILDCON, the index to the clauses. It gives you a very, very quick visual appreciation of the key terms that a good contract, shipbuilding contract, should have. And I suspect there are a lot of lawyers now who, if they're reviewing contracts, will have that on one side. Because obviously when you're reviewing a contract, it's easy to see what's wrong with what is written on it, or in it. It's not always quite as easy to see what's missing. And if you look at that list, that index, you've actually got a list of what should be there, even if you decide to go another route and use a different form of contract. You're looking at quite a good guideline. So, I commend NEWBUILDCON to you and would be delighted to open the floor to discussion. Anything that anybody would like to chat about. I can't guarantee I'll answer the questions, but I'll see what I can do.